If you have been hoping for positive updates regarding your visa application, your green card request, or your family based immigration process, today is the moment you should pause all other activities and watch this video all the way through. Because the information emerging from USCIS, the National Visa Center, and U.S. consulates at present is exactly what thousands of families around the globe have been hoping to receive. There is genuine, measurable progress occurring within the immigration system at this time, and if your application remains unresolved, this development impacts you personally. Stay with me because I am going to explain precisely what is shifting, who gains from it, and what steps you need to take immediately to capitalize on this progress. I am referring to family reunification efforts, green card waiting lists, visa bulletin developments, and several additional topics. If you have never viewed this channel previously, welcome to Immigration Zone, the location where actual families receive genuine guidance about the U.S. immigration system. Let us begin with the overall situation. For years, families have been divided by an immigration system that advanced at the speed of a glacier. Processing durations extended into multiple years. Interview sessions disappeared. The National Visa Center held completed applications for months without any clarification. Individuals were observing their priority dates become eligible on the visa bulletin, only to discover that USCIS or the NVC had not processed their documents. It was aggravating. It was devastating. But a change has occurred, and the statistics are beginning to reflect it in a concrete manner. Let us discuss USCIS initially, since that is the starting point for the majority of family-based applications. USCIS handles Forms I-130, I-485, I-751, I-765, and an extensive array of additional petitions that decide if your family member may enter the United States or modify their status within the country. During the last several months, USCIS has been steadily yet effectively decreasing its unresolved caseload in specific family preference groups. The organization has incorporated personnel at important field offices and service centers. Processing durations for various form categories have in fact decreased, which is not a statement we can make frequently. If you submitted an I-130 for an immediate relative, that is a spouse, unmarried child under 21, or parent of a U.S. citizen, you are examining a group that lacks a visa waiting list because immediate relatives are exempt from yearly numerical restrictions. That indicates once USCIS approves your I-130, the application advances. And currently, approval documents for immediate relative I-130 petitions are being issued more rapidly than they have been in the recent past at particular service centers. For those of you in the family preference groups, F1, F2A, F2B, F3, and F4, the circumstances vary but are still progressing in an encouraging direction. The April 2026 Visa Bulletin, which is the publication the Department of State issues every month to indicate which priority dates are eligible, has demonstrated advancement in multiple family preference groups. The F2A category, which includes spouses and children of lawful permanent residents, has experienced its dates advance in a substantial manner. This is extremely significant because F2A has traditionally been one of the most congested groups, with families waiting years simply for a visa number to become accessible. Advancement in F2A signifies that applications that have been queued are now approaching the beginning. And for certain families, their waiting period is concluding at this moment. Now, let us proceed to the National Visa Center, which is the organization that assumes control after USCIS approves your petition if your family member resides outside the United States. The NVC is the stage where applications tend to remain, or at least that is the perception many families have held. The NVC is accountable for gathering paperwork, payments, and finalizing the procedure prior to arranging a consular interview. For an extended period, NVC handling represented one of the largest bottlenecks throughout the entire immigration system. Applications would remain at the NVC for a year or longer before being forwarded to a U.S. embassy or consulate for an interview. But here is what is evolving at present. The NVC has been addressing a substantial accumulation of documentarily qualified applications, meaning applications where all paperwork has been provided and all requirements are fulfilled, and forwarding them to embassies and consulates at a quicker pace. If your application is documentarily qualified and your priority date is eligible, you are positioned for an interview, and that queue is advancing. Families who have been delayed at the NVC phase are indicating that they are at last receiving interview scheduling notices after extended delays. This is not occurring for all applicants at an identical speed, and it relies significantly on which consulate will manage your interview. Certain consulates possess far greater resources than others, but the overall direction is encouraging. Let us discuss consular processing since the interview represents the concluding phase for numerous families. Following years of COVID-related shutdowns and limited activities, U.S. embassies and consulates globally have been gradually restoring their interview capabilities. Some of the busiest locations, including those in nations with large numbers of family-based immigration applications, have raised the quantity of immigrant visa interviews they are arranging each week. This results directly from additional consular staff being recruited, prepared, and assigned to high-need locations. For families who have been anticipating that interview scheduling, the opportunity is expanding. There is additionally an important development with applications that were earlier denied or sent back at the consulate stage. Families who obtained a 221G administrative processing notice, which basically suspends your application while further examination is performed, are observing those suspensions removed at greater frequencies. Administrative processing durations, which had been extending to a year or longer in certain instances, are decreasing at many locations. If your family member obtained a 221G and has been anticipating resolution, this is the period to examine the status of that application through the Consular Electronic Application Center, also known as CEAS. Now, let us discuss an issue that influences a large number of viewers of this content. The green card waiting list for nations with elevated demand. Citizens from specific countries, including India, China, Mexico, and the Philippines, encounter exceptionally extended waiting periods in the employment-based and family-based preference groups due to per-country restrictions on green cards. This represents a structural challenge that cannot be resolved immediately, but developments are occurring at present that offer some assistance. The Department of State has been utilizing unused visa numbers from earlier fiscal years and allocating them to existing applications in oversubscribed groups. Every unused visa number that gets recovered and reassigned represents one additional family that can advance. Another matter deserving your focus is the expanded application of parole-in-place approaches and other discretionary assistance options that permit certain family members to stay in the United States or request benefits while their primary application is under review. Families of U.S. military personnel, along with certain other categories, have gained from these approaches in significant manners. While these do not constitute lasting resolutions, they function as practical instruments that can deliver security and lawful presence while families await the immigration system to progress. Let us discuss what you ought to be doing immediately if you maintain an unresolved application. First, confirm that your contact details are current with both USCIS and the NVC. Applications experience delays when organizations cannot contact petitioners. Access your USCIS online account and confirm your address and email. If your application is at the NVC, access the CEAC portal and verify that your details are up to date. Second, if your priority date is eligible or will become eligible in the coming few months according to the Visa Bulletin, ensure your application is documentarily complete. Avoid delaying until the final moment to collect paperwork, medical examination outcomes, or police records. Prepare all materials so that when the NVC contacts you or when an interview date becomes available, you can proceed without delay. Third, if you have been anticipating an unusually extended period and suspect your application might be delayed, think about collaborating with an immigration attorney to request information about your application status, or investigate whether a mandamus lawsuit, a legal proceeding that requires a federal organization to proceed, could be suitable. These lawsuits have proven quite successful in recent years at advancing delayed applications. Fourth, continue monitoring the monthly visa bulletins. The Department of State releases the visa bulletin on the first or second Thursday of every month. That publication informs you precisely where the cutoff dates stand for your group and country of birth. Comprehending the visa bulletin represents one of the most effective actions you can take as an individual managing the family immigration procedure. And here's the statement I want to conclude with today. The immigration system is challenging, it is delayed, it is complex, and it does not consistently seem equitable. But progress is occurring. Families are achieving reunification. Priority dates are progressing. Interviews are being arranged. Applications that were stalled are resuming. This is not the conclusion of the delay for every person, but it serves as an indication that the system is functioning and that your application is approaching resolution. Maintain your paperwork prepared. Maintain your details current. Remain knowledgeable, and do not abandon hope. If this video assisted you in comprehending what is occurring with your application or with someone you care about, please provide a thumbs up immediately. It assists this channel in reaching more families who require this guidance. Share this video with anyone who is experiencing the immigration procedure because the guidance in this video might alter how they handle their application. Leave a comment below and inform me about the current location of your application. Whether it is at USCIS, the NVC, or awaiting a consulate interview. Because I review your comments and your experiences, help me determine exactly which subjects to address next. And most importantly, ensure you subscribe to Immigration Zone so you never overlook a video. Every week, I deliver the newest details on USCIS processing durations, visa bulletin modifications, consular activities, immigration policy developments, and practical advice that families like yours can truly apply. Press that subscribe button and the notification bell so you are consistently the initial one to learn when fresh details appear. Your family's path is important, and I am present to support you throughout every stage. Thank you for viewing Immigration Zone, and I will see you in the next video. Subscribe to Immigration Zone.